welcome to Legally Speaking with me, Tarun Nangia. Now we begin the part 2 of our series, which speaks about Indian lawyers choosing to go to United Kingdom and practice there. And of course, when we think of this, then the question arises is, are the working styles different? Well, in India, we know in a very argument-led court, what you speak in court is very important. What you write in the file, is that as important? Or sometimes your argument takes the cake. You know, when a big counsel goes to the court and makes his points and certainly he gets an order, it's a very argument-led court. But are courts different in UK? We don't know. So let us find out. I'll introduce you to my panel, Senior Advocate Parag Tripathi, Senior Advocate Gaurav Banerjee, Mr. Ryan Karanjawala, Managing Partner Karanjawala Company. They join us in the part 2. I'll go to Mr. Gaurav Banerjee straight. In the arbitration work, as well as in arguing in courts, could you explain to us how jurisdictionally there is a difference in terms of, you know, what you choose to argue, how many points you choose to argue in UK, in India, and in Singapore also? Can you explain us both in arbitration and in litigation?
So this is a very interesting point. And for me, this has been really a journey of discovery over the last 7 or 8 years. Working closely with very senior QCs, commercial QCs, against them, along with them. And it's a very different style of work. And there are a number of reasons for it. First of all, the volume. The volume that they deal with is obviously much less than any decent senior counsel in Delhi High Court or Supreme Court will deal. So the volume is less. I remember going to court with a QC, and the judge was complaining because he had 2 matters listed. He said this was too much work for him. So, you know, if I could simply sum it up, it's the difference between a sprint and a marathon. And I'll give you concrete examples as to how this works. So there is great emphasis on the written work. I remember debating with my co-counsel, who was one of the leading QCs, each word, each line, each comma, each full stop. How do you structure your written submissions? You have the luxury of time. Everything is carefully thought through. You have debates about propositions of law. So they go into a matter in much greater depth. They have the time to do that. So a lot more on the written word, a lot less on the arguing style. Let me tell you honestly, the style of argument of our best in India is probably much more pleasing to hear, because there is a lot of passion and a lot. There it is much more dry, to the point. There are, of course, flashes. I mean, if you look at the really top QCs, you know, you have the style, but it's much more cut and dried. The preparation for cross-examination is quite another chapter. I don't think any of our senior counsel are particularly accustomed to doing cross-examinations. And that's a completely different art, which will take an hour or 2 to explain. So that's the fundamental difference. The other interesting thing is that a lot of it is done electronically. So now we are having this problem of, doing everything on VC. But I'm very used to, electronic bundles, 30 volumes, 40 volumes. That's how they operate. And sometimes it gets a bit impersonal. Here you're sitting in a room with your 10 juniors around you discussing matters. There you're doing an arbitration, you're sitting in your room, your QC who's doing some part of the cross-examination is sitting in another room, your junior is sitting in a third room, you're interacting through emails. So to sum it up, they are our brightest and best are as good as their brightest and best, if not better. Our problem is lack of application. We are not used to a marathon. We are not used to a 10-day hearing from morning to evening doing 12 cross-examinations. We are just not used to it. After 30 years to do it is a little difficult. I'm fortunate I've done lots of arbitration, so for me it is much, much easier. So this is one major difference. You mentioned Singapore. The Singapore Chinese are amazingly hardworking. But at the very top, you will find people of Indian origin, you will find people of Malaysian origin, because fluency in the language is still a factor. Davinder Singh is of Indian origin. A lot of the top Singapore advocates are, they have a weakness in terms of flair and presentation. Much more hardworking than the English. I mean, if you have a Singaporean junior, you don't have to do anything. The guy will have flagged every page, researched every judgment, researched everything till the year 1500, and everything will be ready for you beautifully. But to give it a different twist or a little thinking, that the Singaporean middle rank or the Hong Kong middle rank lacks. So that's really the difference. I think at the top level, our senior counsel do find it difficult to adjust to a major arbitration or a major court hearing. I have not seen any of our senior counsel doing major matters, say in the UK Supreme Court or the Court of Appeal. They may be there, they may be briefed, but that barrier has not been crossed as yet. And I think for that, you will have to wait 10 or 20 years till the people who've joined at the bottom work their way up, become QCs and appear in courts. I don't think court practice is something that has really, we have penetrated yet.
That's well to point out that court practice is what we have not penetrated. I'll go to Senior Advocate Parag Tripathi. If that be the case, then do you think that this is the start of a long journey rather than Indians being all over? It is much more time before Indians will really find their place in UK. Because as Mr. Gaurav Banerjee said, that in court practice at least, Indians as ground up lawyers is not yet a common factor in UK. And so the lawyers that have moved have already, in a sense, are achievers in this country and can do some practice in UK. They are not really looking to be there, very busy there. Or am I getting it all wrong? They are going to be busy and have a lot of work, but it will be limited to arbitrations.
You see, we have to also understand the nature of practice in India. In India also, you have the special leave petition courts in the Supreme Court every Monday and Friday, where you don't have the luxury of a 45-minute or 1-hour hearing. So you have to learn, as Ryan was saying after the last show when we were discussing, you have to learn the art of 2 bullets. Maximum you'll get another shot at the pie, and that's about it. So you have to compress your arguments into those 3 to 4 minutes and sort of take the court with you. But even in the Supreme Court and in all the high courts, when you come to final hearing, it's a longish affair and you have to think your point through. But I agree with Gaurav. The amount of effort which goes down, particularly to the written submissions, is unique to English courts and to English and Singaporean jurisdictions. It's not so much in India. In India, rarely will a senior counsel personally sit down and edit or dictate and edit every page and para of the written submissions. He'll just glance through it, leave it to his favorite junior or to a solicitor in whom he has faith. So that part, Gaurav is absolutely right. So but it's a question of being able to switch. And Gaurav is right that when you are on a 10-day arbitration, then your whole focus has to be that arbitration. You have to actually completely immerse yourself in those facts to the exclusion of others. And it helps if it is basically 4 or 5 or 6 such matters which you're doing on a 6-month period, or maybe even a 1-year period. Whereas in India, a busy senior counsel would be doing 8 to 10 matters a day. So therefore, it's a different ballgame. And Gaurav may be again right that as of now, perhaps the Indian lawyers as a whole, the 2 outstanding examples of Indian lawyers in England are doing extremely well, both in arbitration and in courts. But yes, the Indian lawyers as a group have not yet made that mark which they are capable of making. But that is also because many of the top Indian lawyers have not yet made the transition. And as Ryan said, that transition is easier said than done, whether you do it in a step-by-step graduated approach or you do it in an immediate approach, it requires an uprooting of sorts. So it's a difficult decision to take, particularly if you're on the right side of 60, because I refuse to call it the wrong side of 60. So if you're on the right side of 60, it's a difficult decision to make. And of course, as Gaurav says, you need to change your skills. But then my view is, if, for instance, if you're a top pace bowler, it really doesn't matter what the pitch condition is. If you're clever, which you are bound to be, you will adjust your game. But yes, it requires that adjustment. It will require that effort. And it will be some time, I'm not sure 10 to 20 years, but it will be some time before Indian lawyers as a group make that mark in the commercial law scene in England, because that is really the prized area of practice. There, Gaurav, I think, has a point. Yes.
Thanks for sharing this. We'll take a break, and on the other side of the break, we have Mr. Karanjawala who will speak on this issue. Welcome back. Just before the break, we had Mr. Parag Tripathi sharing with us as far as litigation is concerned. He also shared that this could happen much sooner, that in the commercial practice, we'll have a lot of Indian lawyers in UK. I'll go to Mr. Karanjawala. Mr. Karanjawala, in the law firm business, a lot of young Indian grads are making their mark, even if as India desk heads and otherwise. But there are a lot of Indians in law firms in UK, even in America, but in UK more so. So that end, Indians are in a sense achievers, but they don't hog the limelight, so they are not discussed. Of course, people who argue are discussed, counsels are discussed of. Do you think that it is not too far when an Indian will occupy some position, some government position in UK, that will then spur this, in a sense, trend where, a lot more people, a lot more lawyers from India will want to go to UK. We were just speaking the other day, and they say Canada had 6 ministers who were of Indian origin. Same more so, Indians who studied here in India are judges in United States of America in many courts. Indians who studied in law college, law faculty, Delhi University are judges in USA. So, things are changing. People who have studied here are occupying positions within government abroad. Do you think that time is to come now, where in UK also you'll see Indians occupying government positions, of course, in the judicial or law profession, not otherwise. In government, of course, there are Indians.
So, Tarun, first to deal with the point you mentioned earlier, which is how are Indians faring in the solicitor world in London? Now, as far as that goes, except for Talat Ansari, who went as a leading partner of JB Dadachandji straight to America and joined a firm called Kelly Dry and Warren, and that he was able to do because of Union Carbide. The people in the solicitor world over there are people who have usually made it from the nascent stages, from the beginning. They haven't had a roaring solicitor's practice in India and then sort of shut that firm down and then started a firm in England. That hasn't happened. But despite that, there are still people who have headed and have had a large practice. There's a friend of mine called Sunil Gadia, who was heading a firm called Stevenson Harwood. He was the managing partner of that firm. It's a big and well-known firm practicing good commercial law. Then he retired as managing partner. Today is a senior partner in a firm called Cleary Gottlieb, which is an American firm in England, and therefore is much better paid than he was earlier. Nimi Patel is another example. Of course, these are locally bred Indians, people of Indian origin. They're not people who studied in India and went there. Nimi Patel was an important facet of the practice of Herbert Smith. And she was, I interacted with her because she was handling a lot of the Tata work for Herbert Smith. And so on, there have been many people who have had successes even as far as solicitors are concerned. Sarosh himself today is doing far better than he did in his earlier days. Insofar as how far will the councils go in as far as England is concerned, one can never tell. I see in the years to come more and more people keeping one foot. I, before the show, said to Gaurav, you're a foot tenant. And he said, no, I'm a door tenant. So I see more and more people keeping a door tenancy in the chambers abroad, so that over the years, there is an increased interaction between the two bars, the English bar and the Indian bar. And one advantage we have, as Gaurav rightly pointed out, when compared to the Singaporeans or the Hong Kong or the Chinese, is that we are all essentially very familiar with the English language. If it's, for many of us, it's like a first language, even if it's not a mother tongue.
Yes.
So for this reason,
And
the Indian diaspora and Indians practicing law abroad, I think, have an increasingly brighter future.
I want to ask
Also,
you, yeah, after you complete.
Also, when you have people like Salve and Gopal who are at the very top go and start their profession there, then other people are more inclined to look at them and follow their example.
I want to ask you, see, there are lesser known acquisitions. An Indian security company acquired the second largest security company in United Kingdom, which is mainly in the business of providing security guards, so on and so forth, to these people there. So we have always seen this since India's independence, a trend of Indian businessmen, once they have achieved a certain scale, to do acquisitions in UK. These acquisitions were much smaller before Tatas and Mittals and the big guys moved in. But of course, this will only accelerate. Do you attribute the success of lawyers to the Indian businessmen in UK, that they have been responsible for this ascendance?
That's what I tried to point out in the beginning. That's the essential difference between the Indian diaspora of then and the Indian diaspora of now. In those days when Saroj started off, which is the example I first gave you, what happened? There were a few people who were sort of, who were working in banks and at mid-levels, and there were people who had small businesses. Somebody owned a small hotel here, somebody owned a restaurant there. But that was the level of business that the Indians had. Today, it's drastically changed. And as a result of this, obviously, that support extends to the legal community where the Indians are practicing.
That I'll take to Mr. Gaurav Banerjee also this question. Mr. Banerjee, the Indian business succeeding in UK and that leading to more work for Indians, do you see this as a cause-effect relationship? Because you take up arbitrations in UK, as does Mr. Parag Tripathi.
So let me answer one of your earlier questions as to whether you will find people from India in the judiciary. That was one question that you wanted.
Yes.
And that is connected to this as well. So, there are two categories. One is, of course, people of Indian origin. There are now a lot of QCs of Indian origin, and you will soon find some of them in the judiciary, High Court judges, Court of Appeal judges. But for people from India who have sort of Indian nationality, they are now starting off. So they might get and are brightest and the best looking at a Harish Salve or a Gopal Subramaniam and prospects of business will now start at the bottom and work their way up, and in 7, 8, 10 years will be amongst the top. I have no difficulty about that. And what will happen, and you're absolutely right, is at every level, because of Indian business being there, whether it is at my level, or whether it is at Salve's level, whether it is at the very basic level, because of the Indian business, of course, that's a huge bonus. And that's true in India as well. Bombay had industry, and you had great lawyers from Bombay. Calcutta had industry in the 50s, you had great lawyers then it declined. Delhi today is leading the field because of commercial backing and commerce and industry. So obviously, if you have Indian industry there, you have so many more arbitrations now in 2015, 16, 17, 18. There were a few and far between in the 2000s. So obviously, the situation has dramatically changed. So I would agree with Ryan that yes, it's definitely there is a cause and effect. And I'd agree there is a cause and effect.
I'll go to Mr. Parag Tripathi. And see, since you also take up arbitrations globally, do you see work gravitating from the UK also to, because you take it up, could you tell me that even for you in future, could UK be a place where you also would work in addition to a lot of work that you do here in Delhi?
See, once again, as I said, this is both a personal and a professional choice. My international arbitrations, there were quite a few under the SIAC banner. There were a few ICC arbitrations. Wherever possible, I requested for the venue to be in India. That is because it accommodated my Indian practice as well. So this is again a personal come professional aspect. As far as picking up Indian lawyers for British commercial disputes or British arbitrations, whether with or without involving Indian parties, that will depend on depend on us lawyers making ourselves competent enough with the level of competence which they expect at a price which works for them. It is as simple as that. And that will come over time. But on a lighter vein, I am reminded of a couplet of Zauck and the fact that Indian lawyers are gravitating out of India and out of Delhi falsifies his favorite one-liner, which was, "Kaun jaye hai Zauck, Delhi teri galiyan chhod ke." So at least two people have gone, contrary to what Zauck had predicted, after leaving the galiyans of Delhi. And there'll be many more to go. Many more to do is what Mr. Parag said. One final comment from Mr. Karanjawala. We can end. We are almost out of time.
So it's been a very interesting discussion, Tarun, and I'm glad you brought it up because it's out of the normal kind of discussion that we have. And I did feel that this is an important topic because the Indian diaspora and the impact that it has in England and the fact that some of our best counsels are there and a lot of other people are looking in that direction was something that really needed to be debated and talked about. And we're very fortunate that we had Gaurav with us, who's been as he said, is a law tenant and, as you know, has sort of seen England quite closely, both as a student and also working in commercial arbitrations over there. Parag, of course, has a flavor of international arbitration, and that's also added a lot. I myself, as far as our firm is concerned, there have been one or two arbitrations we've done, one which we've done with Parag. If you remember where Sherry Blair was the umpire. So my experience has been much more limited than the other two, but it's been a very interesting discussion. Tarun, thank you.
Thank you so much. A very interesting couplet, as Mr. Parag Tripathi said, that "Kaun jaye teri galiyan chhod ke," as Zauck said, that added a light flavor to our discussion. We will have to find out who all will leave Delhi in the coming days, taking inspiration from those who already have left. I would like to thank each one of you for sparing time and joining me on this very good issue to discuss, and it will spur a lot more thought into a lot of people watching this. Thank you so much for joining us. Thank you so much.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.